Ms. Feltes.
Good morning, Your Honor. Ashley Feltes for the people. At this time, people would waive any conflict in this honorable court. People do not believe that any conflict exists and make a waiver for the avoidance of all doubt.
You know, you're entitled to do that from wherever you are. All right, I'm just letting you know. All right.
Feel more comfortable here.
Okay, no, that's fine.
We'll have that. Good morning. This is the public defender. The public defender likewise does not believe the conflict exists, but if one does, we also.
All right. And the court, for its part, also does not believe there's a conflict either in the Michigan court will vote. The case is decided there. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. Court does call the case of People versus Gary Hall.
Ashley Feltes for the people. And these are both arraignments.
Both arraignments. All right, Mr. Hall, can you state your name, please?
Gary Hall.
All right. Mr. Hall, there are two cases that I need to arraign you on with 3 different charges. All right, sir?
Okay.
Yeah. Starting in case 123-1380. Sir, that is a complaint that alleges that on or about December 11, 2022, location of I-94 near State Street, Pittsfield Township, Washtenaw County, State of Michigan. Count 1 alleges that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge, sir?
Yes, I do.
That's a misdemeanor punishable by up to 93 days of jail, a $500 fine plus court costs, community service, and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand that?
Yes.
On that complaint, count 2 alleges that you did operate a motor vehicle while you're at the same date, same time, and same location, that you did operate that motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand the nature of that charge?
Yes, I do.
That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs, and your vehicle is subject to immobilization. You understand that, sir?
Yes, I do.
All right. In the other case, 123-1472, that is a complaint that alleges that on or about March 30th, 2023, location of US 23 near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan. Count 1, well, the single count on that complaint alleges that you did operate a motor vehicle while intoxicated and lists this as a second offense. You understand the nature of that charge?
Yes, I do, sir.
That makes it a misdemeanor punishable by up to 1 year in jail, a $200 to $1,000 fine plus court costs, community service, any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of the emergency governmental services. You understand all of that, sir?
Yes, I do, sir.
All right. First question I have for you is, do you wish to be represented by an attorney on these cases?
Yes, Your Honor.
Yes?
Yes.
All right. So public defender cases.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Hall, we would waive any further reading. My client would stay in mute as to all charges in both cases. I would ask for an adjourned pretrial date, and then also if Mr. Hall knows what his expected out date may be, if he maybe could comment on that.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea in both cases. Mr. Hall?
Yes.
Do you know when you're going to get out of jail there?
It's the 27th on Thanksgiving.
You'll get out on the 27th?
Yes.
What kind of charge are you being held on?
It's a stalking charge. It's a misdemeanor. I got 90 days and 22 months probation. And a few other things too. I think I got to wear a GPS tether when I get out too for about 45 days.
Okay. So the 27th is when you're out?
Yes.
All right. I will adjourn this when it's fine. First date, December.
December 3rd.
I'll adjourn these matters to December 3rd, 2025, 9 a.m. or as your invite indicates. All right, sir?
Okay, so do I get out on the 27th? Or am I on a
Well,
hold here?
that's up. That sentence was imposed by Clare County, correct? Is that correct, sir?
Yes.
Okay, I don't have anything to do with whether or not you get out on the 27th.
Oh, that's my out date. I was just asking if I'm gonna be on a hold, because they're supposed to call Ann Arbor to see if I'm able to get out or not because of the misdemeanors.
Well, do you think if I set it for the 3rd, you're gonna be able to get down here? Because otherwise I'll put a hold on you and we'll come get you.
Well, I can be on Zoom. I can get on Zoom now. I couldn't get on Zoom before because I just moved out to Clare County. I didn't have Zoom because I didn't have Wi-Fi. And I got
Your Honor, if I
Wi-Fi
may-
now. I can get on Zoom, talk to you.
Mr. Hall, yeah, Your Honor, I think he's just asking if he was receiving PR bonds in this case, which would be my.
Well, I know what he's asking, but I mean,
But I mean,
Here's
if you
what
want to
I'll
come down to
do.
the courtroom, I'm sure I can get my dad to bring me down there, to the courtroom on the 3rd.
I'll adjourn this matter to December 3rd, 2025 at 9 a.m.
Okay.
I'll set his bond in each of these cases in the amount $10,000. Do you have the alleged BAC on these matters?
Yes, Your Honor. So one was 0.15/0.14. It's an older case. So it was not the intoxilizer, it was the data master. That one was a stop for speeding. The other is a 0.116 single vehicle crash.
And they were, okay, and there was.
And then the priors from 2016.
Got it. Okay, so on the case ending in 1308, I'll set his bond in the amount of $15,000 personal recognizance, standard conditions, including no assaultive behavior or any possession of any weapons. There is also to be no use of any alcohol, recreational marijuana, or any illegal drug. I will indicate that you are to report to community corrections for placement on a scram tether unit on these matters. And then this one is adjourned out. On the other case ending in 1472, I will set his bond at a $25,000 personal recognizance bond. Standard conditions, including no assaultive behavior or possession of any weapons. No use of any alcohol, recreational marijuana, or any illegal drug. I will also sign a community corrections order placing you on the scram tether unit. You are to present yourself, which is you're going to have to get yourself down here because you're going to have to present yourself to community corrections for that tether. You're really to do that within 24 hours of your release. Understood?
So you're saying I have to bond out within 24 hours? Or, when I get released, you're saying when I get released?
When you get released, you've got
Okay.
personal recognizance on these cases. When you get released, you need to get yourself down to community corrections because from the time that you're released, you need to report within 24 hours.
Okay, so if I can't get a PR bond, can I get out on the 27th so I can do that?
Mr. Hall, you have
I
a
just
PR
gave
bond.
you 2 PR bonds.
Okay.
Okay?
This case involves Gary Hall, who appears before the court for arraignment on multiple charges across 2 separate cases. The judge carefully explains each charge, making sure the defendant fully understands what he is facing. In the first case, Mr. Hall is charged with operating a motor vehicle while intoxicated, along with driving while his license was suspended or revoked. These are misdemeanors that carry possible jail time, fines, vehicle immobilization, and additional court-ordered programs. In the second case, the charge is even more serious. Mr. Hall is accused of operating while intoxicated as a second offense. Because it is a repeat charge, the potential penalties increase significantly, including up to 1 year in jail and higher fines. Mr. Hall confirms that he understands all of the charges and asks to be represented by an attorney. The court appoints a public defender, and not guilty pleas are entered on his behalf.
All right.
These cases will not be holding you.
Okay. That's all I don't.
When you get out, you have to get down here to community corrections so that you can be placed on the scram tether unit.
I hear you. Okay. So as soon as I get out, do this. Okay. Now, I'm on probation here too when I do get released. So how is that going to work, Your Honor?
Mr. Hall, when you get released, call the public defender's office, okay? Because I also believe you'll be released on a holiday and community corrections may be closed, so I need to further instruct you, okay? So definitely call the Washtenaw County Public Defender's Office, all right?
On the 27th? Or on Monday?
Call me tomorrow. You can call me tomorrow would be great, or when you're released. But if you do not call me, still go to community corrections with the first business day after you're released.
To do this.
Okay, I'll give you a call.
Fine.
Thank you, Mr. Hall.
Thank
Are you going to be able to do all of this, Mr. Hall?
What was that, Your Honor? I couldn't hear you.
Are you going to be able to get all this done?
Can you repeat that, sir? I didn't hear you. Sir?
Are you going to be able to do what I told you to do?
Yes, sir. I will. I promise you.
Because if you don't, I'm just going to change your bond and we'll bring you down.
I promise you I'm going to do what you told me to do, sir. I promise.
Your Honor, not to complicate things, I do have a question. Is community corrections open the day after Thanksgiving?
I have no idea.
Holiday.
I don't think they are.
Okay. So yeah, Mr. Hall, call me as soon as you can at jail, all right?
All right. I promise I will. Thank you.
Thank you, Mr. Hall. Appreciate it. Thank you, Your Honor.
You know what I'm going to do, because that's Thanksgiving holiday and it may not be open. I'm going to also order that when you report to community corrections, they're to give you an EBT test, because I want to see if you've been drinking.
Okay.
All right. Thank you.
Thank you, Mr. Hall. We'll be in touch. Call me.
Thank you. I will.
All right. Take care.
You too, sir.
The discussion then shifts to Mr. Hall's current jail status. He explains that he is already serving time on a separate misdemeanor stalking charge and expects to be released around Thanksgiving. The judge makes it clear that the current court has no control over that sentence, but stresses the importance of appearing for future court dates. Bond conditions are then set. The judge issues personal recognizance bonds in both cases, with strict requirements. Mr. Hall is ordered to have no alcohol, no recreational marijuana, and no illegal drugs. He must also report to community corrections within 24 hours of his release and be placed on a scram tether to monitor alcohol use. The judge repeatedly emphasizes responsibility and compliance. Mr. Hall promises multiple times that he will follow every instruction, understanding that failure to do so could result in his bond being revoked and his return to jail. This hearing highlights how seriously the court treats repeat DUI offenses and bond conditions.